Chair recognizes Representative Geren.
Thank you, Mr. Speaker and members. I know it's going to be a long day, and I appreciate your patience and attention. We spent a large number of the past few months working out to make this bill that focuses on upholding the rule of law and allows our law enforcement agencies across all levels, local, state, and federal, to exercise every resource provided under current law to keep the public safe and remove bad people from our streets. It's been my goal to make sure this bill does so in a way that respects every person's rights and liberties. I have met with virtually all stakeholders impacted by this legislation, and I'm fully aware of the many differences of opinions that we're going to have about this. With that being said, I want to be clear about what this bill does and does not do. This bill prevents local entities from adopting policies that hinder the ability to uphold immigration laws already on the books, and it requires local law enforcement to comply with immigration detainer requests. The bill carries stiff civil penalties for local entities who enact sanctuary city policies and allows the removal from office of sheriffs, police chiefs who refuse to comply with immigration detainer requests. The bill requires local law enforcement agencies to uphold and comply with laws already in place. The bill does not target or discriminate illegal immigrants. In fact, this bill has no effect on illegal immigrants if they have not committed a crime or hanging out with someone that has. This bill specifically targets criminals who happen to be here illegally. The bottom line is, if you don't do something to get arrested or hang out with somebody that does and taken to jail, this bill's not going to affect you. Under Section 1.01, the policy section, it defines campus police departments, immigration laws, institution of higher education, and local entities, and it exempts the following from the bill: hospitals, hospital districts, public health departments, public and charter schools, and religious organizations. This section prevents local entities and campus police departments from adopting any sort of policy that prohibits the enforcement of immigration law. Local entities cannot prohibit their officers from inquiring into the immigration status of an arrested person or prohibit the sending or receiving of information to and from the U.S. Citizenship and Immigration Service, or ICE. It also states that local entities and campus police may not have a pattern or practice of prohibiting enforcement of immigration law. Originally, the Senate version used the term discourage. By using pattern or practices, it raises the bar on what the state must prove. This term is used in other laws to show an entity has an unwritten policy that would violate the law if written. The change allows a defense for an entity acting in good faith, but if that entity has a pattern or practice of violating Committee Substitute for Senate Bill 4, it is not operating in good faith. The bill also prevents local entities and campus prohibiting officers to assist or cooperate with federal immigration officers when requested. That prevents them from not allowing federal immigration officers to enter and conduct activities in a jail when enforcing immigration law. This bill does not require entities to develop any new policies. It simply prevents entities from adopting policies that prohibit the enforcement of immigration law. The bill strictly prohibits local entities and campus PDs from discrimination based on race, color, religion, and national origin. It establishes a complaint section, which is a process which allows citizens to file a complaint with the AG if their entity adopts a policy or measure that prohibits compliance with enforcement of immigration. The section would allow citizens of their respective jurisdictions to file a complaint with the OAG if the entity allegedly violates Section 752.053 and adopts a policy or practice or prohibit. The OAG, if the OAG determines complaint is valid, the OAG may then take them to court. The OAG may recover expenses incurred from the suit as well as court costs, attorney fees, investigative costs, witness fees, and deposition costs. If an entity is found in violation of this section, the civil penalties will kick in. If an entity is found to have violated the policy provisions of this bill, the entity is subject to fines of up to $25,500 per day until the policy is removed. This is the main enforcement mechanism in preventing local entities from adopting sanctuary cities policies. Penalties collected under this go to the Victims' Crime Fund. In this situation, sovereign immunity of the state and government immunity of a county and municipality is waived. The community outreach policy, this section of the bill was created to allow law enforcement agencies covered in the bill to educate the public that peace officers may not ask the immigration status of a victim or witness except under very specific circumstances. If an agency develops a community outreach policy, it must include outreach to victims of family violence and sexual assault. Under Section 772.0073, the grant program, it defines the Criminal Justice Division, immigration detainer requests, immigration laws, and local entity, and it requires the Criminal Justice Division to create a competitive grant program to provide financial assistance to offset costs related to enforcing immigration laws or complying with the detainer request. In implementing this program, the Criminal Justice Division shall establish the following: eligibility requirements, application procedures, evaluation, and so forth. The Criminal Justice Division may use any revenue available for this purpose. Article 2, the immigration detainer requests, IDRs. The bill requires law enforcement agencies to comply with, honor, and fulfill any requests made with an IDR. The agency must inform the person if they are being, the person must be informed that they are being held pursuant to an IDR. An agency does not have to perform these duties if the person provides proof of U.S. citizenship.
That's what he intends.
Section 2.02 is a completion of
Mr. Speaker,
Mr. Oliveira, for what purpose?
I can barely hear Chairman Geren. Could we have better order, please?
The House will come to order.
Thank you, Mr. Speaker. The completion of sentence in federal custody, this allows for the state, if a person is confined in TDCJ up to a week before their sentence is up, to transfer the person to federal custody. In other words, this keeps the state from holding a person once they've served their sentence and allows them to transfer them to the federal custody up to a week before their sentence is completed. Defense of local entities in suits related to IDRs, if requested by a local entity and the OAG determines the local entity was acting in good faith, the OAG must defend the entity if they are sued for their part in complying with an IDR. If the OAG defends an entity in this circumstance and the state is found liable for the expenses, costs, and judgment, the state is not liable for these costs if a local entity was not represented by the OAG. The surety bond section is in here to address some bail bondsmen who are basically crooked and are taking money, and Representative Longoria brought this to us, and we've got some perfecting amendments for it. Section 5, the failure to comply with immigration detainer requests, removal of sheriff, constable, or police chief. The Senate's version of this bill allowed for removal of state grant funds when failing to comply with immigration detainer requests. By doing so, they allowed for the removal of funds that go towards vital community service, such as veterans courts. My version of the bill takes the grant language out and instead addresses the root of the problem by allowing for removal of those truly responsible for not complying with IDRs. Under this section, a sheriff, constable, a police chief knowingly fails to comply with a detainer request, they can be charged with a Class A misdemeanor. The Article 6, under this section, when investigating a crime, an officer may only inquire into the nationality or immigration status of a victim or witness if it's determined necessary to for the investigation or to provide them with federal visa information for the victim or witness protection. It does not prevent an officer from conducting a separate investigation of another crime. And this bill also includes the severability section, so if any part of it is found unconstitutional, it does not void the rest of the bill.